Hello, and welcome to this week's episode of the Illinois Appellate Roundup, where we tackle recent Illinois appellate and Supreme Court decisions that represent important developments in appellate and post conviction law. Today, we'll be addressing three cases: one on ineffective assistance of counsel and the limits of forfeiture in post conviction, one on issue preclusion after a partial acquittal, and one that packs three post conviction lessons: youthful sentencing, actual innocence, and ineffective assistance into a single opinion. For each case, I'll give you the holding stated plainly and the takeaway for your own practice. This week, the docket is unusually rich. Two decisions came down from the Illinois Supreme Court on the very same day in May. One asks whether a lawyer's mistakes can still be raised after a conviction is already final. The other asks what happens when a jury says not guilty to one charge while three others are still waiting their turn. And our third case, decided in June by the First District Appellate Court, is a single opinion that quietly teaches three different lessons at once. Let's get into it. Start in Alton, Illinois, in the summer of 2010. Bonnie Woodward was 47 years old. She worked at a nursing home, and on the afternoon of June 25th, she finished her shift, walked toward her pickup truck in the employee lot, and was never seen again. Her truck was found with the doors locked and the windows rolled down. Her co-workers remembered seeing her talk to an unfamiliar man near that truck, and they remembered an unfamiliar gray sedan in the parking lot. It took 8 years. In 2018, the state charged a man named Roger Carroll with her murder. The case turned, in part, on a fingerprint and a palm print, lifted from the outside of Woodward's truck and matched to him. In 2020, a jury convicted Carroll of first-degree murder, and he was sentenced to 65 years. The appellate court affirmed that conviction on direct appeal. So far, this sounds like an ordinary, if tragic, murder case. What makes People versus Carroll worth your time is what happened next, in the post-conviction proceeding. Carroll filed a post-conviction petition arguing that his trial lawyer had been constitutionally ineffective. He raised a whole list of complaints. That counsel failed to highlight that he had been excluded as the source of certain DNA samples. That counsel didn't move to change the location of the trial, given the pre-trial publicity. That counsel hired a fingerprint expert, but never put that expert on the stand. The trial court dismissed the petition at the second stage, and the appellate court affirmed, but it did so in part on a procedural ground. It held that Carroll's ineffective assistance claims were forfeited because the court reasoned he could have raised them in his first direct appeal, and he didn't. That single word, forfeited, is where the Supreme Court fixed its attention. So here is what the Illinois Supreme Court actually held. It held that the appellate court was wrong to treat those claims as forfeited. Claims that a trial lawyer failed his client often depend on facts found nowhere in the trial record. Conversations that were never transcribed, decisions made off the page, things the lawyer simply never did. You cannot fault a defendant for failing to raise, in a direct appeal, something that the direct appeal record could never have shown in the first place. So the forfeiture ruling could not stand. But, and this is the part that decided the case, Carroll still lost. The court went on to examine every one of his claims on the merits, and it held that not one of them made a substantial showing that his constitutional rights were violated under the familiar two-part test from Strickland versus Washington. The absence of DNA, for instance, had already been hammered home by the defense at trial, so the dismissal of his petition was affirmed. The court also held that his post-conviction lawyer had given him the reasonable level of assistance the Post-Conviction Hearing Act requires, and it confirmed that the standard is the same whether that lawyer is appointed by the court or privately retained. And here is the takeaway. Do not let a court wave away your post-conviction ineffective assistance claims with the word forfeited. If the claim rests on something outside the trial record, and most real ineffective assistance claims do, post-conviction is exactly where it belongs. But clearing that hurdle is not the finish line. This case is a reminder that surviving forfeiture buys you nothing if you cannot then make a substantial showing on both halves of the Strickland test. Win the procedure and then win the substance. You need both. Our second case moves us to a traffic stop on Interstate 90 in Kane County in September of 2021. A sheriff's detective pulled over a car for following too closely and changing lanes without signaling. A man named Terry Collins was in the back seat. The detective smelled cannabis, searched the car, and found a loaded handgun in a bag in the trunk. Collins was arrested. Now follow the charges carefully, because this whole case lives in the procedure. Prosecutors charged Collins with 4 counts. The first, aggravated unlawful use of a weapon. A second count they would later drop. A third, possessing a firearm without a firearm owner's identification card. And a fourth, unlawful possession of a weapon by a felon. Collins asked the court to sever that fourth count, the felon in possession charge, from the others, and the court agreed. The state then chose to try that severed count first. At that trial, both sides agreed that Collins had a prior felony, so the jury had only one thing left to decide. Did Collins actually possess that handgun? The jury said no. It acquitted him. And that is when Collins turned to the counts, still waiting, and said, "You cannot try me on those either. Every one of them also requires proving that I possessed this gun, and a jury has already found that I did not." The trial court agreed as to the firearm owner's identification charge, but not as to the weapons charge. The appellate court went further and held that the doctrine of issue preclusion barred both. Issue preclusion is a simple idea with a stubborn name. Once a fact has been actually decided in your favor, the state does not get to relitigate that same fact all over again in a second proceeding. The state took the fight to the Supreme Court, leaning hard on a decision of the United States Supreme Court, Currier versus Virginia, which had read the federal protection against double jeopardy quite narrowly. Here is what the Illinois Supreme Court held, and it was unanimous. It held that Currier versus Virginia does not control here. That case interprets the federal double jeopardy clause, a constitutional floor, a minimum guarantee. It does not require Illinois to read its own law down to that same federal minimum. Illinois, the court explained, gives defendants broader protection than the federal constitution demands, both in its common law and in its own criminal statutes. And under that broader Illinois protection, once the jury necessarily found that Collins did not possess the firearm, the state could not turn around and relitigate that very same fact by prosecuting the counts that depended on it. The appellate court was affirmed. And here is the takeaway: 2 lessons, one practical and one strategic. The practical lesson: in Illinois, an acquittal that necessarily decides a fact in your client's favor can close the door on later charges that turn on that same fact. And our state's protection is wider than the federal double jeopardy floor. Do not assume the federal case is the ceiling, because in Illinois, it is not. The strategic lesson, severance, and the order in which charges are tried are not mere housekeeping. The sequence here: sever the felon count, try it first, win it, is exactly what created the preclusion that sank the rest of the prosecution. How you carve up the counts and the order in which they go to trial can decide the entire case. Our third case takes us back to Chicago, to a May evening in 2003. 3 to 5 young men in dark hoodies walked into the middle of a street and opened fire. A young man named Kevin Horde Jr. was shot in the head and killed. 3 eyewitnesses identified Walter Campbell as one of the shooters. In 2012, a jury convicted him of first-degree murder. Campbell was 21 years old at the time of the killing, and he already carried a separate, earlier conviction for first-degree murder, along with 2 attempted murders. Because of that prior murder conviction, the sentencing judge in 2013 had no discretion at all. Illinois law made natural life the mandatory sentence. The conviction was affirmed on direct appeal. More than 20 years after the shooting, Campbell finally got a full third-stage post-conviction hearing, the kind with live witnesses on the stand. The trial court denied him relief, and on appeal, he raised 3 separate claims. That is why People v. Campbell earns its place on our docket. It is really 3 lessons in one opinion. First, he argued that his mandatory life sentence was unconstitutional as applied to him because at 21, his brain, SOTS, like a teenager's was still developing. That is the argument that grows out of the United States Supreme Court's decision in Miller versus Alabama. Second, he argued that he had newly discovered evidence of his innocence, 2 witnesses surfacing years later who said he was not one of the shooters, And third, he argued that his trial lawyer was ineffective for failing to put in a prior statement from his mother, placing him at home at the time of the shooting. Here is what the First District Appellate Court held. Three holdings, really. On the sentence, the court held that the mandatory natural life term did not violate our state constitution's proportionate penalties clause as applied to Campbell. Why? Because he pointed to nothing but his age. He identified no disability and no unique distinguishing circumstance that tied the science of youth to him in particular. On age alone, the court deferred to the legislature's judgment and affirmed. On innocence, remember, this claim got a full hearing, and the trial judge watched the new witnesses testify. One of them was himself a convicted murderer who claimed he just happened to cross paths with Campbell in a prison library 18 years later and to have been standing at the exact spot at the exact moment of the shooting. The second witness claimed he knew Campbell was not one of the shooters, even though, by his own account, the shooters' faces were covered with scarves. The trial judge did not believe either man, and the appellate court held that this credibility finding was not against the manifest weight of the evidence. Under Illinois' test for newly discovered evidence, the proof must be new, material, and conclusive in character, and that last element, the conclusive character, matters most of all. It failed here. And on the lawyer, the court held that even if the mother's earlier statement could have come in, the decision not to use it was a matter of trial strategy. The mother's statement to police did not even match her testimony cleanly, and there was no reasonable probability that putting it in would have changed the outcome. Affirmed on all three. And here is the takeaway. This single opinion is a clinic in why post-conviction claims fail. If you are raising a young adult sentencing challenge, a birth date is not enough. You have to connect the neuroscience of youth to something concrete and specific about your individual client. If you are raising actual innocence, your case rises or falls on whether the new evidence is truly conclusive and on a trial judge's credibility findings, which are extraordinarily hard to overturn on appeal. And a decision not to use a prior consistent statement will almost always be cast as trial strategy, rarely a winning theory of ineffective assistance. Know where the hard ground is before you start digging. So there is the through line this week. Three cases and three reminders that in appellate and post-conviction work, the procedure is the merits. Carroll tells us that forfeiture has its limits, but that surviving it is only half the job. Collins tells us that in Illinois, a single acquitted fact can end a prosecution, and that our state protects defendants more generously than the federal floor. And Campbell tells us that the hardest claims, youthful sentencing, actual innocence, ineffective assistance, demand specificity, not slogans. That is your roundup for the week, and every case is real, recent, and published, so you can read each one for yourself. Thank you for watching this week's episode of the Illinois Appellate Roundup. If you are in need of appellate or post-conviction representation, please do not hesitate to call me directly at 312-517-3877. I'll see you next week.